Доброго дня.
Good morning.
Починаємо засідання. В засіданні беруть
We are going to
участь
start the meeting. There are members of the Public Council of International Experts, Norman As, Robert Brookhuizen, Mary Cat Butler online.
На зв'язку.
Can we see Mary? Is she online?
Mary is not present today.
Ага, окей. Отже, Мері Батлер зараз не бере участь в цьому засіданні.
So she's not participating in this meeting. Gabriela Yotkaite, John O'Sullivan, and Jessica Lott Thompson, members of the High Qualification Commission of Judges of Ukraine. Mihailo Boganis.
Ярослав Дух, Роман Кадисюк.
Ярослав Дух, Роман Кадисюк, Надія Кабецька, Ігор Кушнір, Олексій Омелян, Андрій Пасічник, Роман Сабадаш онлайн, Руслан Сидорович, Олексій Чумак.
Головуючим є я, голова комісії Андрій.
I will be the chairman, Andrei Pasishnik. There is the secretary of the meeting, Irina Lapushnak. We have the quorum and the special meeting of the High Qualification Commission of Judges and the Public Council of International Experts is open. I will enumerate the matters on the agenda. We will assess the compliance of candidates with the criteria according to Article 8 on High Anti-Corruption Court. The list of candidates, Chaykin Ihor Borysovych, Roy Олена Олександрівна, Криклива Тетяна Григорівна, Кравченко Іван Олександрович. Will there be any other suggestions? No. Who is voting for approval of the list of items on the agenda? Unanimously. Thank you.
Дякую. Перелік питань затверджено.
Thank you. The list of items is approved. Let's start considering the first matter. Please invite Chaykin Ihor Borysovych.
Доброго дня.
Good morning.
Розглядається питання щодо відповідності
We will consider the
корупційного суду Чайкіна Ігоря Борисовича
compliance of Chaykin Ihor Borysovych with the criteria provided by Article 8 of the Law of Ukraine on High Anti-Corruption Court. There are members of the Public Council of International Experts, Robert Brookhuizen, Norman As, Gabriela Yotkaite, John O'Sullivan, Jessica Lott Thompson, members of HQCJ, Андрій Пасічник, Роман Сабадаш онлайн, Руслан Сидорович, Олексій Чумак, and others.
Ви маєте право заявляти відвід,
You can file petitions and with the permission challenge or express your objections. Will there be any recusals? No. All right. The rapporteur on this item on the agenda is Omayan Serhiy. Please, the floor is yours. Good morning. The candidate Chaykin Ihor Borysovych in 2003 graduated from the National Legal Academy of Ukraine and got full higher education in the area of legal sciences. In 2008, the candidate defended his PhD thesis. The topic was legal regulation of risk insurance on financial services markets and got the status of a PhD. As to professional activities, in period from 2003 till 2006, the candidate was a PhD candidate of the National Legal Academy. Later, he worked as an assistant professor of the department of the National Legal Academy. Starting from 2009 till 2010, was the associate professor of the Department for Civil and Commercial Law of the Academy of Judges of Ukraine. Till 2011 was a senior research fellow of the National Academy of Science of Ukraine. In 2012, the candidate was appointed for the period of 5 years to the position of judge of District Court of Kryvyi Rih City. In 2019, the candidate was appointed for an unlimited period. The candidate also has an attorney's license. In issued in 2020, the candidate currently participates in the competition for the position of a judge of an HACC, and he's a candidate to get the position of judge of Kharkiv Court of Appeal. He's also participating in the competitive selection to the post of local court judge with a position of transfer. The candidate previously participated in the selection procedure to fill in 21 vacant positions of the court on intellectual property. He also participated in competitive selection to the Court of Appeal of The Hague. It was announced in 2018 when the results of the competitive selection confirmed his ability of administering justice in the Court of Appeal of Hague, but he was 12th in the ranking, so he wasn't selected and to fill in the 10 vacant positions. He also participated in the competition to the position in the appellate chamber, and he ceased participation in the stage of practical assignment. He was never brought to disciplinary liability. It should also be indicated that there was a special check within this competition, and the candidate corresponds to the requirements provided for by the law. That's it from me. Thank you. Would you like to add something in terms of your basic information? Thank you. Everything was correct. Excuse me. You said there were 12 vacant positions to the Chamber of Appeal. If I'm not mistaken, there were 14. It's important that you confirmed your ability to fill in this position. Thank you. Thank you, Mr. Robert. The floor is yours.
Thank you, Mr. Chair. Gabrielle, next to me is the rapporteur, so please go ahead, Gabrielle.
Thank you, dear Chairperson. Hello, Ihor Borysovych. I'm your rapporteur from the PCI side. And first of all, I would like to congratulate you coming so far in this competition. And some organizational issues. First of all, I would like to emphasize that we will discuss only the information that you provided to us already. Other issue is that we are very time limited, so please be very concise in your answers. So first of all, I would like to define or detail your answers in relation to your professional experience. You mentioned that you have 14 years of judicial experience, including handling complex cases, war crime cases, and so on. So maybe you remember some type of corruption cases that you handled during your experience as a judge.
Thank you for the question, Gabriela. As to the cases related to corruption, I haven't handled such cases as a judge, but there was the Article 368 related to bribe that I considered. I considered administrative offenses involving corruption. Since it's a local court, I considered cases related to the traffic of drugs, state high treason, and we had cases under the jurisdiction of Kherson courts and Bakhmut courts. I have a huge experience of working within a panel of judges as a member of a panel, and we've considered a lot of criminal proceedings. Thank you. If necessary, I can give more details.
Not necessary at the moment. The next question is also related to your answer. How your experience can benefit the High Anti-Corruption Court if your participation will be successful?
Thank you for the question. I think that this experience will benefit the court because I have 14 years of experience as an investigative judge. Every year I was selected as an investigative judge, and as we know, a lot of criminal proceedings are considered with the hack, and we also have a lot of experience because we were transferred some cases under the jurisdiction of other courts that are currently in the areas of active hostilities. So we have to consider cases where the terms of consideration are expiring, and sometimes it's not easy. Thank you.
So thank you for your answer. And the next question is related to your priorities. As I understood from your material that you're now participating in 3 parallel competitions. So what your priority? What competition is your priority?
Thank you, Ms. Gabriela. As to my priorities, well, I will not name what's my plan A and plan B, since all the procedures of selection coincided in time, and my participation in one selection doesn't guarantee that I will become a judge of the Hague or the Court of Appeal or the Court on Intellectual Matters. I think my experience will be useful in any court. As to the Hague, here is my card confirming the participation 8 years ago in the 3 competitions. So my life was analyzed 3 times by the civil society organizations, the media, the Commission, the Public Council of International Experts. So I spent a lot of time, I invested a lot of time in these selections.
And the last question from this this information is: if you will be offered only the first instance judge position to Hague, will you accept such proposal?
For me, it's one court, it's one institution. Yes, there is the appellate chamber, but I do not see a significant difference between working in the first instance or the appellate chamber. I do not have priorities in this sense. I applied to the appellate chamber when there were such selections, but now I see no issue if there is a certain ranking and the Commission and the PCIe entrust me with this right. I will, of course, consider this possibility, and I will select the first instance.
Thank you. Now we are going to the next part of the questions, and they are related to the usage of full access to the register of court decisions. You also know and gave us some explanations about your researches, about yourself and your family members, and during 10 years periods, we think that it was searched more than 100 times. So do you confirm that you made all these searches? Yes or no? Just short question.
Yes.
And in your written explanation, you also indicated that since the end of 2024, discussion has arisen regarding the possibility of using full access. And since then, to avoid doubts about your integrity, you avoid using full success because you think that it is against Code of Judicial Ethics. So should we understand that before 2024, 2024, you did not consider that the use of full access to such information about yourself or your related persons are consistent or inconsistent with judicial ethics?
Мені треба трошки часу для цієї відповіді. Якщо можна,
No,
я розкажу це
if I may, I will explain in details because it's a serious matter. First of all, the State Unified Register of Court Decisions has 34,000 decisions signed by me, and there are millions of requests. I wasn't getting familiarized with the matter, with the materials of cases, but I'm sure that there are a lot of them. In particular, I participated in the procedures for selection of judges. There we can find questionnaires and requests from public councils. There are questionnaires filled in by the judges. First, they only contain certain questions like, do you confirm that there were no criminal proceedings against you? You were not there were no subpoenas to you, and I can use this full access to maintain my independence, integrity, to prove integrity, and provide answers to civil society organizations, because I'm sure that the information I am asked about is available to me, and when I'm asked, do you relate to a certain case, I will either have to say I do not know, and that the full interview will contain such answers I do not know. So I had to use the full access, and I described the cases when I had to request the full access. You know that there were several publications about me and some requests of law enforcement authorities to get my personal information, and I had to decide whether to react to such requests or just accept such normal activity of law enforcement.
Yeah, yes, thank you. You explained this, and as I understood, it is related to your participation in the first competition to The Hague. But nevertheless, these searches started a lot years ago, so in 2014 and 2015, and they were regular ones. So at least several times per year, you checked about yourself, wife, and other relatives. So how can you explain this?
Пані Габріело, це не було системно.
Ms. Gabriele, it was not something systemic, in my opinion, because what investigative actions or searchers mean. You can check that there is a plaintiff with the same last name as me, but different first name. He's not related to me, but there are approximately 1,500 claims to get permission to conduct searches, etc. And they are non-standard, non-typical, not provided for by the Code of Criminal Procedure. So some searches were related to that coincidence. Some searches were related to the data relevant to me and my family members. First, there was a provocation within administrative corruption offense, and I applied to the Prosecutor General and the High Council of Justice. On this matter, I was recognized as a victim in this case. The investigator studied my calls, my phone, documented everything, and that was the end. And I wanted to clarify that. Thank you.
Thank you. Just a remark, you cannot answer this, but in Lithuania, in criminal law, we say that system is 2 and more times. So 100 times, I think it's already a system. Nevertheless, it's during 10 years.
Можна
But you- yeah.
одну дуже коротку ремарку.
Very briefly,
Зробити маленьке уточнення, що
I should clarify that there were systematic attempts to put pressure on me. There were systematic provocations against me. For example, Radio Liberty, Radio Svoboda would publish something, but it was a mistake and I was not informed of certain things. So these situations do appear, and there was an explanation of the Council of Judges that it's not a potential conflict when I search myself, and I want to underline that every case is accompanied by the operational units, and they can see the grounds for access, and every judge can delay the publication of their decisions in the Unified Register. And since I have the full access, there was no such danger. But retrospectively, it was necessary to provide full explanations to the request of civil society, the Commission, and the Public Council. Thank you.
Yes, and you on the same explanation you can use telling us that you made these all searches in the time not related to your work hours, yes? After the working hours. All the searches, most of the searches were made after working hours.
Пані Габріела, якщо я вчора
Ms. Gabriela, yesterday I tried to calculate it using the AI, and every 1 hour and a half, on average, I have to consider a case and I approve a judicial decision. I cannot say that I have working hours and the time after working hours, because sometimes I work on weekends, etc. That's specifics of my job. I think it's the same with the hack.
So the last question in this part, it's related to your judicial assistant. So you searched her name as well and other information. How can you explain this?
тільки один раз в зв'язку з тим, що
Only
надходили
once,
запити,
because there were requests about her, and then there was an article published. I think we will discuss it further. And indeed, back then I searched by her name to confirm or dispel this information. It happened once.
але це була дуже резонансна публікація.
But it was a very high-profile publication.
Thank you. So we can go to the next part of my question. Is related to your wife's premises owned by your wife. You explained, and we know from your declaration that she owns 3 premises, 2 non-residential premises and 1 apartment. So in relation to and they are owned by your wife since 2006. And in your explanations, you explained that the apartment with the area of 83 square meters, living apartment, has been rented out since 2025. But how this apartment was used before this time? How can you explain this or comment on this?
Так, дякую. Інколи ми там проживали.
Yes, thank you. There were periods when we resided there, when we are coming to Kharkiv. Since the start of the war, we allowed our relatives to live there for 2 or 3 weeks, not more.
Free of charge to the relatives?
Ну, оренда ні, оренда це
The lease was paid for.
And do you declare this lease in your declaration or in wife's declaration?
Щодо оренди, звісно, це буде
As to the lease, of course, it will be declared in March this year. To be honest, there were so many requests that I had to do other job, and the term expires on the 31st of March.
So now going to not premises, but not residential premises of 86 square meters approximately. You indicated that you gifted it to your mother-in-law in 2026 this year, yes?
Я прошу, це має набути до шлюбу, я нічого не дарував.
Excuse me, it was the property that I acquired before the marriage. I didn't gift it. Yes, my wife offered it, gave it as a gift to the mother-in-law, but it's not related to the competition. In autumn, she announced this intention, and she then realized it.
And how they were used before 2026?
Наскільки я знаю, перепрошую, наскільки я знаю, воно не
As
використовується.
far as I know, it was not used.
В Харкові взагалі складно.
In Kharkiv, it's quite hard to use anything right now because it could be damaged. I provided the photos, and it's visible that there are some damages.
And your wife also owns the bigger one, premises of 118 square meters that was damaged as a result of the war. And you also indicated that you are not using these premises, but you are paying the rent. Not rent, but bills, maintenance bills. So how can you explain that you are keeping, or your wife is keeping premises which are giving no benefit, nothing?
Ну, як ви бачите, вже одну подарували.
Well, as you can see, one piece of real estate was gifted, so there is the apartment, which basically remains the only residential premises we have, and the other office remains. But now, if we decide to sell it, it will be basically a gift because it is located very close to the high military institution to train pilots, and the attacks happen every night. I provided the certificate which proves that the electricity supply costs 70-80 hryvnias, and it's not used and cannot be used today.
Thank you. So now we can go to another part of the question related to your apartment that you are living in. So you declared in previous declaration that you are using it free of charge. And you explained that this apartment was given to you for the usage for if you will renovate it and furnish it. So could you specify what repair works were carried out and what total amount of expenses you incurred for this purpose?
Дякую за запитання.
Thank you for the question. That incurred cost was not calculated, and there was no such request. If there was such a request, I would probably calculate. This apartment was repaired back in 1990s, beginning of 1990s, so it was a long time ago. There were no plastic windows, only wooden windows, which could not perform their functions. I probably should have made photos, but there was no such request for PCIe, so there was no items inside, and my wife's colleague provided this apartment. If it was someone else, we probably wouldn't do it. We tried to calculate that if it's a wife's colleague and she cannot influence us in any way, we do not have intersecting professional activities, so it would be proper.
Thank you. And you started paying rent since 2020, yes? And but in the owner's declaration, we can see the gap between 2022 and 2023. They don't indicate any rent payments. So how can you explain that? We can see payments in 2020. 21 and then afterwards in 24, 25.
Дякую. Це не зовсім так, бо там
Thank you. It's not exactly like that because you are referring to the declaration of the person who provided the property for rent, but this person could provide other things for lease, and that's the first time I learned about her declarations from the request of the Public Council of International Experts. As far as I remember, the written agreement was of 2024. That was the agreement I have, and it was specifically signed to be able to declare these sums to avoid any doubts as to integrity of the use of this property. Before that, there were payments made. I could show the extracts about these payments for 2022, and it was not a rental payment, a lease payment. It was rather what we talked about before, a compensation of exploitation costs and certain improvement of property. I would call it like that.
And the last question from this part is about rent amount, because in 2020 we can see that approximately you paid 12,500 hryvnias per month, and in 2024 this sum reduced up to 5,000 hryvnias per month. How can you explain this decrease of rent payments?
Я перепрошую, такого питання не було, пані Габріела.
So I didn't have this question before, Gabriela. I could explain it by the fact that in the declaration of the owner, it was split by months. Because they have other real estate objects, it was the general amount. In Kryvyi Rih, we didn't have such rent amounts for apartments. In other procedures, there was an issue regarding this. Certificates were submitted to show the monthly rent amount. In Kryvyi Rih, so in Kryvyi Rih, there are a lot of real estate objects, but there are not too many new residential complexes, but there are a lot of old infrastructure objects. And therefore, the rent may cost less. Because of the war and the relocation of citizens within the country, the situation might have changed. And the rent that is indicated was the one I paid.
Thank you. So my next question is related to your wife's parents' activities, but we will not go deep into the information that is not for publicity, just in general terms. So her parents presented her several gifts, big ones, and for that reason, I would like to ask, can you explain very generally what is the business structure of your wife's parents? They appear to be founder of one entity together, but also they conduct business as individual entrepreneurs. So did they carry out the same or similar activities through both the company and their individual business, or they are different?
тут важливий момент, що це було до того,
It's
як
important to say that it was before we were appointed judges. After that, she had stopped her entrepreneurial activities. She went through checks and completed
I'm
her.
talking not about your wife, but about your parents of your wife.
Якщо можна, тоді в мене клопотання про... Я
Because,
зрозумів.
yes,
Я
because
перепрошую, я не зрозумів. Тоді в мене клопотання...
Okay, so I apologize. Then I would like to stop the broadcast, and I submitted the explanation before. If we could suspend the broadcast for this
can I
part.
remark? I just asking very general, not in deep. I saw this request, but only very generally. The activities similar or different? Not going deep into the type of activities or.
Давайте ви спробуєте відповісти
Я перепрошую, я
потім,
знімаю.
які ще, на вашу думку, не буде розкривати якусь сенситивну
So
інформацію,
you
якщо
could try to
це
describe and answer the question, describe the activities in general. And if you feel that there is a need to disclose more sensitive information, then we could suspend the broadcast and consider your motion before that. Okay, I will try. So this is a company where they have a word to say. 2% belongs to the mother, 2% to the father, 14% to the brother, and this is quite a big amount. The types of activities, I have already described them in my explanations. They also have passive income because they buy real estate. All that real estate is purchased on the basis the share ownership at early stages of construction, and then this is how they preserve their assets.
But they, as a private entrepreneurs, they perform the same activities, or these activities are different from the entities' activities? Yes or no? Just.
Я, чесно кажучи,
To be honest,
я думаю, що це відмінна діяльність. Я
I
поясню.
think these are different activities. There are certain assets, and the external economic activities are risky. Sometimes their cargo would be lost. They would risk bankruptcy. So that entity is a LLC, and they have statutory capital. They're partners, but the capital that belongs to them is used by them as physical individuals in case there is a force majeure, and because this is an LLC, they could be safe from claims on the part of their partners.
So can you exclude the possibility that they use this individual entrepreneur status self to reduce the tax burden of the entity?
Так, звісно, вони отримали
Their activities are transparent. In 2 years, they have received a status of payers with a big share of tax payments. There is a status that the tax agency grants to some entrepreneurs.
The next block of question is related to decrease of savings that you have and declared in 2022 and 21. This was explained by you that you supported your son, who went abroad. And could you clarify where exactly your son resided during this period of not immigration, but when he stayed abroad? And on what legal basis?
Зараз він живе Дякую.
Now he
Ви
resides
з нами, але
with us,
ну, з початком повномасштабного
with this onset of the full-scale invasion, he was in Kharkiv, in the epicenter of the hostilities, and by March we managed to evacuate him. And we changed our mind in early days of 2022, February 22, very quickly, and in the end it was decided that our parents would take him up and take him to a safer place where they lived. So first they were in Ukraine, Khmelnytsky Oblast, then prices skyrocketed for rent and for many things. Almost the whole of the east of Ukraine moved to the western regions. Then they went to Czechia and Bulgaria. After that, my son returned either in late August or in early September. You could check it.
And you made this support made to him transferred to your wife's mother, I think. During 1 week, you made several transfers that not exceeded 110,000 hryvnias. So why do you do such thing? Just every day, the sum not exceeding this amount.
У мене було 3 моделі поведінки. Перший це
So I had 3 models of conduct. First, I could hope that the governments of those countries would provide for my son, but it was quite inadmissible. We decided that we needed to provide mostly for our child. We couldn't rely on social benefit, and also there were other more vulnerable categories in need of social benefit. And we wanted to stay in Ukraine to work, to make money, but our son is what matters in our life, and we really were puzzled about how we could support him better abroad. It so happened that with the full-scale invasion, we needed to support my brother, my brother. So, and they also would transfer money to us, and
Yes,
this is how it went.
But the mechanism seems such that you made these transfers in such manner that to obey the obligation to declare the significant expenditure. Because it was made, as I said, during 1 week, every day, the sum not exceeding 110,000 hryvnias.
Так.
Yes, that's right. So, are you suspecting that I evaded declaring these costs in this
I
way?
am asking you.
Я розумію, дякую. Ні, я таким чином не...
No.
Це з травня було, нібито перший там переказ.
So the first transfer was in May. In August, there were also a couple more transfers, but the reason was transfers returned to Ukraine. Because they spent the money on the child, we wanted to compensate them for this. And beyond that, some procurement was made, and they would transfer property so that they also spent money on that.
So you think that this type of activity is not suspicious, that you on 22 July August 22, 23, and 24 made the transaction of not exceeding this amount. For the just
Пані Габріела, 2022 рік, мені
Gabriela,
здається, дуже
in
важливим
2022,
саме поведінка моєї родини. Чому?
so our conduct could be suspicious from the first glance, but if you really comprehend the situation, the full-scale invasion, relocation, these were the money that we had in order to support all those expenditures, and all those transfers were done cashlessly. These were bank transfers, and they all reflected my bank record from on my bank account, and it was all taken from my judge's remuneration, and it was done through bank transfers. And regarding different situations, so indeed, we need to really understand what period we are talking about. We could relocate in a few days between different regions of Ukraine, and they also needed to somehow uphold their entrepreneurial activities. They could have no money at one period and lots of money in a different period.
Thank you. And my last block of question, really one or two maybe question. As I understand from your declaration that during the period of 2018 and 2024, you served on the board of NGO named Association for the Development of Judicial Self-Government of Ukraine, which opposed to the adoption of the law number 5068, which introduced open competition to High Council of Justice and introduction of ethical council. So, and you declared that this was supported, that Venice Commission issued the opinion that such draft law is not good. But I took out this not decision, but recommendation of Venice Commission, and they say that they are welcoming such type of law because it's implement transparency in these procedures. So, short comment on this.
Yes, thank you for this question. So this is a well-known application that everyone knows about, but nobody signed. So that was a decision taken by a panel. And since 2019, I have met international experts, and in my humble opinion, PCIe was made possible. That is, PCIe was the one that acknowledged that I was able to administer justice within the appellate chamber. And my position was positive. But regarding the delays, the procedures that take up to 7 or 8 years, or even 9 years, of one procedure where I'm taking part for 9 years, probably it was about this.
Thank you. No questions from my side.
Thank you, Gabrielle. I'm just looking around me. No. On the screen, Norman. No. Back to you, Mr. Chair.
Дякую, пане Олексію. Дякую. Пане Ігоре,
Thank you,
більшість моїх
Igor.
запитань,
Most of my questions may seem insignificant to you. They pertain to declaring as a declaration, but it could also clarify your attitude to this matter, and you will need to tackle such situations and cases once you're appointed head court judge, potentially. So number one is inappropriate declaration of corporate ownership rights. You founded 3 companies. In declarations of 2015 to 2016, you declared the first entity, and regarding the second entity, you never declared it. It was dismantled in 2017, and the third entity in 2019. So when's my question? Thank you for this question. That issue was studied during the first competition to the appellate chamber of the Hague Court. So regarding the export methods, I provided the documents. I don't know whether the Commission received them. In 2016, there were modifications to the law on the status of judiciary. And according to those modifications, we decided to dismantle that LLC. It didn't carry out any activities, and I provided all the conclusions of the checks, and no one would take up the non-existing assets. In October, a check was initiated in order to dismantle that LLC. In December, an order was done to carry out a check. The LLC was dismantled, and the check indicates zero turnover. And I didn't take part in that LLC. The second entity, I actually didn't take any documents regarding this because it seemed to me that that issue had been handled already in the first competition. In 2009, commercial court decision was made regarding the dismantlement of the entity, and the first time I ran in the competition for the appellate chamber, I was asked that question, and it was solved. Thank you. So, formally speaking, in your opinion, regarding the case law that you used, Article 172, Part 6, are there any violations here or not? Look, so I reviewed the High Council of Justice case law and analyzed it, but I don't think there are any violations. The declarations for 2021-2022, as I compared them, I noticed that you indicate the income from National School of Justice as a part-time job, and you indicate it as part-time job. In the previous year, you say that you got the income based on a civil contract. Is there a mistake, or did you were you hired by the school? Can I answer? Yes, you can. So, if before the school concluded civil contracts and type of activity was defined differently, then at some point my contract lapsed, ended, and then I would just provide some lectures, courses on criminal law, and we decided to formalize our relations in a different way. Was it done as a part-time job? No, I don't think so. Then the question regarding the subjects of declarations in 2024, in the declaration on marital status in 2024, you state Chaykin Ihor Borysovych as an individual cohabiting with you. In the asset declaration for 2024, you say that she is your wife. I understand that in October 2024, a decision regarding your divorce came into effect. And this might be a reason why you reflect that family member status, but still it's unclear why there is a difference. Thank you. In my asset declaration, I stated that following the Corruption Prevention Agency recommendations, and because we have been married, but at that time I said it like this, and in my declaration of marital ties, marital status, I remember there was a note there, but I don't have it before me. But I remember that the divorce did not affect my manner in the manner in which I was supposed to fill out my asset declaration. Then disciplinary action against you. Are you familiar with this case? There were a couple of cases, a couple of claims. One is still pending. When I reviewed the claims, I thought that they were all already discussed. Could you please remind me the essence of the question? So it's about part of the claim that says that the plaintiff wanted to get bank details from the defendant, and they submitted a motion to receive compensation. The claim was registered in February. It was considered in March, and the plaintiff talks about disciplinary action because they state that they wanted to settle the dispute peacefully, but you interfered with this. You hadn't let you both do it. That case, that claim was considered within a simplified procedure, but do you think that the defendant's conduct really aimed at resolving the dispute peacefully or not? Commission isn't becoming a disciplinary body, but we would just like to hear from you about ways to settle disputes peacefully. So many cases that are considered pertain to compensation for professional illnesses, and regarding the specificity of our city, moral damage and professional illness are quite spread. But I don't really recall that the enterprise would acknowledge that they they generated the grounds for moral damage and professional illness to arise. So I think it's premature to talk about such damage, and I need to consider the materials before giving you an opinion. Okay, thank you. No other questions. Colleagues, questions? None? Roman? please.
Пане Ігоре, добрий день.
Ігор,
Уточнююче запитання у вас.
morning.
Ми вже питали,
One
що
clarifying question. PCIe members already asked you regarding your searches in the Unified State Register court decisions, and as it was said, and as it was asked you in writing, there were searches of mobile phone numbers. Because one thing is to look for a surname in terms of an administrative offense, or another thing, searching for mobile phone number. Thank you. So it was about situation when I accidentally noticed that my mobile phone is indicated in a criminal case to which I have no relation. And in order to understand whether I needed to respond to this in some way, whether to turn to the Prosecutor General, the High Council of Justice, I carried out that search. Also, there were cases when I would receive calls and I informed the High Council of Justice about that. Investigation was carried out in order to preserve my reputation and my honor. I did that. But how about mobile phone numbers of your relatives? Same thing. So if you take the analytical certificate that I provided, there are all the cases when my relatives were indicated in some unrelated situations, and I needed to check it in retrospect and come at some conclusions. Any other questions? PCIe members, do you have any other questions?
No, thank you.
Добре. Дякую. Отже, відповіді ми одержали.
Thank you. Then we have the answers, and now you have a chance to clarify something, provide additional information if necessary, but please be concise. I would like to say thank you to the Public Council of International Experts, the Commission, Secretariat of the Commission, Secretariat of the Public Council of International Experts. Sometimes I would get the requests at 1 a.m., so they were not sleeping and trying to clarify about my integrity. Thank you. It's very important for me to clarify everything. There were many questions, and I was getting ready to answer every question. And I'm sorry that we don't have much time, because I wanted to voice everything, because it's the only platform where I can preserve my good name. In any case, I want to say thank you to everyone. I think that your choice will be right. Thank you. Thank you for your participation, and we